you can do business in a way where you have no limitation on liability. In other words, if your company gets sued and you lose, they get your house, they get your car, they garnish your wages, they seize your bank account. Generally speaking, those are bad things. You don't want to do that. However, if you're not selling product right now, or you're in a business where you don't think you have very much liability, well, it costs money to set up and maintain a limited liability entity. So you might want to hold off on filing these until you really need it. But as a general idea, it's not wise to operate without some kind of limitation on your personal liability. However, during that period of time, you need to nail down your intellectual property, you nail down your relationship with your co-founders. What happens if you need money and two of the co-founders can pony up $10,000 and the third guy doesn't have a penny? How is that going to change your ownership? What you need to do is you need to get a founders agreement in place, and you'll be just fine. However, once you're starting to sell, or once you're starting to do things to other people that might cause them to sue you, you want some kind of limitation on liability. Now, what most of you don't want, and you've probably been reading about, although we have one attendee who might want, remember, corporations are creatures of state law. Every state has different things going on. California has just authorized two new types of corporations, a benefit corporation and a flexible purpose corporation. Generally speaking, as an entrepreneur, don't do it. You got too many things on your plate. And these are things that can ruin your company, ruin your life kind of problems. Don't strap on the extra problems of getting involved with some kind of innovative new thing where the laws have just been passed, they haven't been tested in the courts. You don't want to turn up as a test case in the California Supreme Court. On the other hand, if you're doing something that you're doing as some kind of social purpose, one of the problems with a traditional corporation is that corporations are set up in such a way that you, as a director of a C corporation or an S corporation, have a legal responsibility, and it's a pretty serious one, to maximize returns to the shareholders. So you're doing something that's generating toxic waste, but it's cheap. Well, you have a legal obligation to keep generating and if you say, no, I'm a good guy, I'm going to get into some kind of remediation program, boy, it's going to cost the corporation a hell of a lot of money, but I'll feel good about it. You literally can be sued by your shareholders for breach of fiduciary responsibility. So that's why these corporations have been set up. Be aware that they haven't been around for very long, which means, yes, there's a section of the California Corporations Code that describes how they work, but it's not quite bleeding edge, but it's definitely leading edge. You're going to have some bumps on the road as you try to figure out how to work these things.